Okay, and then we'll move on to the section 106. I don't really have much to say about the section 106, but I've got a few things about the conditions. I won't go through every one of them because I've already had a look, and I'll just talk about the ones that I need to discuss. First of all, I'm assuming these have been agreed between the parties. Yeah, okay. The only thing with that is, I mean, it's great that they've been agreed, of course. It's not signed. I don't seem to have it's not signed or anything, so there will be pre-commencement conditions on it, and I'll need some kind of agreement from the appellant.
Madam, it's an outline permission for which the pre-commencement consent requirement doesn't apply.
Oh, right. Okay. Sorry. Thanks. Okay, that's great. So, number one, the details. Normally, we just say details of scale, appearance, layout, rather than say of the building, because there might be other things apart from, well, there will be other things apart from buildings. So that I've just got the PIN standard condition, which I will just read to you. Where is it? Okay, yeah. So what I would normally put is application for approval of the reserved matters shall be made to the local planning authority no later than the expiration of, well, it would normally be 3 years, but I know you want 2 here. Beginning with the date of the grant of this outline permission, and the development to which this permission relates must be begun no later than the expiration of 2 or 1 year from the date of approval of the last of the reserved matters to be approved. And then we have the second one as details of the appearance, landscaping, layout and scale herein after called the reserved matters shall be submitted to and approved in writing by the local planning authority before any development begins, and the development shall be carried out as approved. So that would normally be that your first and second condition. Does anybody have any objections to that?
No, Mum.
Okay. Right, thanks. Okay, and then, yeah, so then you've got the condition restricting it to 80 dwellings. So I'll just scroll down to the next one. The next one is, I think, is your condition 6, beginning with concurrently with the first submission, the reserved matters under condition 1, that one. Okay, so the beginning of this one, it says concurrently with the first submission of the reserved matters. That would normally, I think, be before commencement of development. I'm just wondering why you've got a lot of the conditions start with concurrently with the first submission.
Ma'am, I believe that's how the council standard conditions were written, although I know they are under review currently. I think in essence it was to try and avoid or minimise the amount of development commencement conditions within their standard list, so as to try and keep things as simple as possible for getting development off the ground, so to speak.
I think, Mum, sorry, just to add to that, Mr. Civvy's comments, I think also because landscaping is obviously a reserved matter, how the site is landscaped will obviously go some way towards how the site can be enhanced in terms of biodiversity. So the council's view would be, if we're considering landscape as a reserved matter, we should be considering the biodiversity enhancements at the same time. Otherwise, the landscaping scheme, which may get approved for reserved matters, may subsequently need to be amended to reflect the appropriate level of enhancement as well. So just trying to cut down on that and deal with it as one issue.
Okay, I've not seen them written like that before. I'm just wondering. I can see your logic now that you've explained it to me.
I mean, the council wouldn't have any objection, though, of course, if you amending that in some way, or using a PIN standard condition if there is one to that effect.
Yeah, well, it would be probably before commencement of development, that kind of thing, or before something else has happened, like the foundations are laid or something like that. I'll have a think about it. I don't know whether the lawyers might want to comment on it because it's just an unusual wording, but it's been agreed by both parties. But I wouldn't mind it if the advocates can just confirm that they're okay with that.
So just so I understand the issue, Madam, it's that in condition 6, the trigger point is concurrent with submission of reserved matters rather than prior to commencement or prior to first occupation or words to that effect.
Yes, yeah.
Well, I think there's a broader point here as well about speed, isn't there? That if you're thinking about speed of delivery, it might be sensible to have one streamlined way in which all of these matters are agreed rather than being discharged and then there's some further hurdle to commencement. Would be the only thing I'd add. I mean, in legal terms, as the trigger point is entirely within the discretion of decision makers subject to the tests.
I'm just thinking of the test of reasonableness to have everything being required at that point. That's all.
From a legal perspective, ma'am, I agree with Dr. Bowes.
Yeah,
it's
okay.
It's within your discretion. From a reasonableness and the conditions, test for conditions, I think it's okay. It's a practical speed of delivery point, as my learned friend said.
Okay, all right. Okay, well, if you both think it's reasonable, then that should be all right. So also in that one, is there any provision for implementation of the biodiversity enhancement strategy? I wasn't sure. I mean, it could have a timetable of implementation within it that could be required.
Well, is that not covered, Madam, by the work should be implemented in accordance with the approved details?
Well,
is it that there's not an express time to? Oh, I see. Yeah. Well, that could either be written into the condition or it can be part of the details that the applicant would submit.
Yeah, I just think that perhaps if I were to include maybe as F under the bullet points, just timetable of implementation, that the strategy should include that. Okay.
Yes, indeed. Yeah.
All right.
Thank you.
And then in number 7, I think I've got the same comment. Preparation. So under F, I've got, it says preparation of a work schedule. So perhaps we could have implementation included in that as well. Okay. And then the paragraph after all those A to H, the LEMP shall also include details of the legal and funding mechanisms. I'm just wondering if that's a bit vague and how they would be secured by way of that condition.
So, yeah, if I can help, Mum. So that would be our ecologist standard wording. I suppose it covers the eventuality, but a developer might come to some agreement with another party, like a parish council, to manage the open space. But as the unilateral unilateral undertaking has been submitted, it indicates that a management company would be established to manage all areas of open space within the site. So I think it's just a little bit broader, just in case there was something else to happen.
Yeah, all right, that's fine. Okay, and then the final line of that, the approved plan will be implemented in accordance with the approved details. So I did say when, but in my notes, but if we have the implementation clause in under F, then that should secure that. Okay. Okay, number 8. I wrote some notes on that. Let me just read that to myself. Okay, again, that was just to do with the concurrently thing, but you've answered that, so that's all right. Right, so number 10, I'm okay with number 10. Just with some of them, we do have standard conditions that that we use, or I've got a list of them. So would anybody have any objection if I made sure that the requirements were the same? It's just that I know the wording of the PIN standard condition is very well tested. So that was the tree protection one. I can't see anything wrong with that particularly. But if it may be that sometimes when I write conditions myself, I notice afterwards that I need to amend them.
I have no objection to that.
Yeah, from our perspective, no harm at all. These, I'm very grateful the local planning authorities produced these, as Mr. Jones says, they come from their standard set of conditions. There are some standard conditions that the council have, they put on outlines that we have agreed have come out for various reasons. So the basis is the council standard conditions rather than obviously the PIN's conditions. So, but yes, I think that the effect is the same. So we are very happy either way.
Okay, thank you. Right. Okay, so I'm just looking at number 14 now. I'll just have to read it again just to remind myself what I said. Okay, so that is the archaeological condition, and it was the last sentence which says this will result in the completion of a post-excavation analysis, preparation of a full site archive and report ready for deposition at the local museum and submission of a public report. Is that something that the appellants are going to do? I just thought it was a little bit vague about what the requirement was about that. When I say appellants, I mean the developer rather, whoever has permission.
Yes, I in my experience in other local planning authorities, it's a fairly sort of standard condition that's dealt with usually the county council in terms of 13 sets out basically agreeing a scheme, and then 14 is obviously implementing and doing the post-excavation assessment, and then that information is submitted, obviously to the LPA, and deposits are made with county councils and museums, and that's fairly standard, is my understanding.
So who deposits it with the museum? Is it the council or the developer?
Usually the process is, my understanding is, if anything is found on the site, a request is made for any findings to be taken to a local museum. They're on the landowner's land, but so that it is essentially given away to be deposited at a museum. So I'm sure if that answers your question. A request is made and it is granted usually, but obviously that condition requires that that information is deposited.
Yeah, so I need to know what the requirements of the condition actually are upon the developer.
I think, Ma'am, if I can help with that, my understanding would be that the report is submitted to the council's historic environment officer, and it's usually the developer's contractor who does it, because obviously it's usually a specialist contractor. They would deposit it with the museum or the historic record office at the same time as they submit it to the historic environment officer at the county council. So it's the onus would be on the developer to make the submission to the relevant body.
Okay.
Yeah, agreed.
Right, that's okay. I might have to reword that somehow to make it clearer. I'll just make a note of that.
Sorry, just to be clear on that, Mum. Obviously, the first sentence says that it will be submitted to the local planning authority. So I think what Mr. Jones meant by it would go to the heritage officer. It would be submitted to the council first, who would then forward it on to the heritage officer.
Yes, I understand that.
Because obviously the conditions have to be, these would obviously be well, normally, I know it's an appeal, but normally there'd be the council's conditions, of course, the local planning authority's conditions.
Yeah, that bit's okay because it says it will be submitted to the local planning authority, and what they do with it themselves is for them. It was just the bit about this will result in the completion of, I wasn't clear about, but I get that now, but I think I will have to reword that slightly, but that's okay. Okay. So just scrolling down to number 19. So this is about foul water drainage. Is that not a building regulations matter? Is the condition necessary?
I think, Mum, the condition was a recommendation of Anglian Water, who are the statutory undertaker. So we've taken the recommended condition to make sure that it's done. But if you feel it's covered by building regs, then we wouldn't mind the condition being removed.
Okay. Right, so then we have a number 20, we've got a landscaping condition. I don't know whether it's necessary because landscaping is a reserve matter, so that all that stuff needs to be submitted anyway. I don't know whether it's necessary to have a specific condition requiring what's got to be put in.
No, I can see what you're saying. It could almost be an informative, which I've realised, of course, you wouldn't impose on an appeal decision. Yeah, I mean, as long as Ms Jones has anything he'd like to say.
Well, yeah, sorry, I was just going to say, Mum, I think we've found it useful in terms of it establishes clearly to the developer what the council's requirements are in terms of a landscaping scheme. I think we've over the years seen a variety of landscaping schemes presented to us, some of which is very scant on detail, others which are very detailed, and really the purpose of the condition is to make it clear the level of detail that we require, and then also the condition at the end obviously does go on to say about sort of implementation and also making sure that anything which becomes diseased or died during the first 5 years is replaced. So we're trying to cover that through the condition as well. Yeah,
see, I would expect that to be on the reserve matters, that last bit about the stuff dying and being replaced. I still don't think it's necessary. I don't know if anybody else wants to come in, because informatives are very different to conditions. Dr. Ashley Bowes perhaps might want to comment.
Thank you, Madam. Well, it's necessary in the sense that it regulates what the reserve matter would need to have to be discharged, but perhaps it could be amalgamated into condition 1 to say that the landscaping details must include details of then the following. Doing it. Or you not being able to impose an informative could in your decision letter say that it would be necessary for any reserve matter to specifically address these points, and that would be what the planning authority would need in order to properly discharge that condition. I suppose it's really a matter of fairness to the developer who's building out the site, so they know what's expected to save validation delays, really, so that they're aware of what the planning authority needs, so there's not weeks and months of delay whilst there's pinging backwards and forwards about details.
Right. I'll have a think about that. It's a bit unusual. If I do allow the appeal and I don't apply it, I'll say why in the decision. Okay, and then number 21, the last sentence, which says, under no circumstances should any other external lighting outside the curtilage of dwellings be installed. I would just, it's me being pedantic, I would have just said outside the curtilage of dwellings within the site when referring to dwellings, that's all. I don't think it would
more
be
precise.
Yeah, that's all. I don't think it'd lead to any problems if that was left out, but it just seems better to have it in.
Or delete the under no circumstances. And just leave. Is that what you were canvassing? No other external lighting outside the curtilage should be installed, that bit. Not under circumstances.
Yeah, no, I could amend that bit as well. I was just wanting to make sure that it applied to only no external lighting outside the curtilage of dwellings. Well, basically just making it relevant to the site. It probably doesn't actually matter because, of course, the permission only relates to the site. But I can put no other external lighting shall be installed. Hang on.
Outside the curtilage of the dwellings hereby approved.
On the site. Let me think. Okay. So no other external lighting shall be installed outside of the curtilage of the dwellings. But I think that's all you need, because so that allows people to put external lighting on their own properties. It doesn't prevent them doing that. I don't like the without prior consent from the local planning authority because that leaves it a bit up in the air. It gives somebody able to go back to the council and just ask them via a letter without any kind of public consultation. So, do you know what I mean? It's a tailpiece, basically.
It's an impermissible tailpiece, I think.
Yes. Yeah. Okay. Right. Just let me amend this so that I remember. So I've changed that sentence now to no other external lighting outside of the curtilage of dwellings will be installed.
Yes.
Okay. Okay, then down to number 23. That's about gates, fences and walls. I'm wondering if that's necessary. Would it not be part of the landscaping and appearance reserve matters?
Well, in my experience, we haven't dealt with it, and developers don't tend to deal with it as part of landscaping. But that's based on my experience, Mum. So that's why we usually have the condition. And again, going back to the point earlier about making it clear the details we would require with the reserve matters, it's helpful to the developer, and it also avoids the need for a condition which would need to be discharged after reserve matters was approved. So that's why it's included.
Okay, all right. And is the appellant happy with that?
Yeah, I think it kind of works both ways, and obviously those details will be provided. And if the LPA requires it in that form, or whether it comes through the other conditions, and I think Mr. Jones probably is right that it isn't purely landscaping. It will be part of the reserve matters in essence, but it's about the first occupation there. So rather than that those are provided at first occupation. So I don't see an issue particularly with the condition as proposed, because it's about enclosure at first occupation rather than purely submitting those details at reserve matters.
Okay. All right. And then number 24, the yearly logs of the maintenance of the SUD scheme. So presumably that'll be in perpetuity forever and ever. I don't really. I'm not saying that, you know, there's anything wrong with this. I just haven't seen. I can't remember seeing anything like that before about a SUD scheme. So it seems, I don't know whether it's a bit onerous, but I'll listen to what you've got to say.
So thank you, Mum. If I can help, perhaps. So that is a standard condition from the lead local flood authority, which in our case is Essex County Council. So that is something which we have on as a standard condition, and developers generally understand that. Obviously, it's usually the management company that will be taking responsibility for the maintenance of the features. I think we have had some instances on other developments where there has been instances of flooding, and where the condition wasn't applied when we or the local flood authority have asked for details of maintenance. The management company have been unable to provide them, so we're unclear as to where the fault might lie. So it's kind of trying to avoid that eventuality in the future, and trying to make sure that the management company, you know, do keep a record of what they're doing and maintain it in the approved manner.
Okay, that sounds.
I think just to add to that, because you know, many developers do use sort of underground storage crates as well to sort of reduce the flow of waters. You know, there is a danger if they're not regularly serviced or desilted that they can become ineffective. So I think that, you know, that sort of supports what Mr. Jones says with regards to that being necessary.
Okay, all right, that's fine. Number 25, noise. I'm a bit puzzled by this, why it's necessary. You know, I've seen them in town centres when there's dwellings approved next to noisy uses, but I'm not sure why that would be here. Mr. Jones.
Yes, thank you, Ma'am. So I have to be honest, I had relied when we was drafting the conditions with Mr. Carville on the response from the environmental health officer, and that was a recommendation that that she had made. I have to be perfectly honest, I hadn't read the noise assessment report submitted by the applicant. I had relied on the environmental health officer's consultation response with the condition. However, I did earlier this week have a look at the noise report just to refresh my memory, or to see what had happened that led to the condition in advance of this session, and I couldn't find a reason within the report as to why the noise condition had been applied. So I have to be perfectly honest and say that if you didn't feel that was appropriate, I wouldn't be able to argue against that.
Okay. All right. I from unless I go there and find out it's a really really busy road, then I think it's unlikely I'm going to think that's appropriate.
I think there is a little bit of noise from the railway, but it's an infrequent service and it's at some distance, and you may sometimes with prevailing wind get a little bit of noise from the A120, but I think and certainly I think Mr. Tibby and myself have both been to site on a number of occasions, and I think we'd both concur that noise isn't a significant issue on the site. It is quite a quiet, tranquil sort of countryside area predominantly. So
yeah, well, that's been the council's case, so okay. All right, thank you. Now, next one. No, I think that might be the end. Yes, that's all of them. Okay. So I'm assuming that nobody wants to make any more comments about the conditions. Let's say if you do. Okay, right, that's great. So let me just go to the planning obligation. I don't actually have, I've had a look through this and nothing has jumped out at me. It's not dated at the top.
Mum, it won't be dated because we also have this session with you, and if you require any amendments to it, and yes, it's been signed, so as soon as it would be dated, it would become a deed. So that's the reason that is not yet dated. So if at the end of the session we can have the document dated, and then we can provide a certified copy to your office.
Okay, that's fine. I don't have any questions. I'm assuming that the council is has checked this and.
Mum, you may not have seen it, but Mr. Jones sent through last night to PINS the council's seal compliance document statement. But no, I mean, I think obviously aside from comments at the Highways and Accessibility Roundtable about the necessity or otherwise of the school transport contribution.
Yeah.
Obviously, we as are the appellants, are happy to leave that to you to determine if of course you're so minded to allow the appeal and whether to retain or strike out that blue pencil clause.
Okay.
But aside from that, I think pretty much everything else is a sort of a policy standard, really, as per the compliance statement.
Right. Okay. I haven't received that email yet, but if it's on the way, then that's good. So it was sent last night. It's probably
Yeah,
just
I think it was about 7:30 last night. So
right.
no doubt it will be on its way to you shortly.
Okay. All right. That's great. Okay.
Thank you.
So if there's nothing more to say on that, then we can move on to closing submissions if you're ready. But if you want a break.
Yes, may I just have 5 minutes to print them off and email them to your case officer, madam, please?
Yeah, absolutely. I'll give you a bit longer just in case it takes because I've had this before where there's problems with printers and all sorts of things. So if I give you 10, if we come back at 10:15, that should still give us plenty of time to finish before lunch. Okay. All right.
Thank you, Mum.
Okay. Thank you. Okay, thank you. I've just read the closing. Thank you, Dr. Bowes, and the extracts from the dictionary.
Ma'am, I'm terribly sorry.
Yes.
Might I ask for an additional 10 minutes or so? My computer has just, everything is frozen. I can't open Dr. Bowes' email. I'm in the middle of editing my closing, which I have the spinning donut of doom going round. It's one of those unfortunate issues of perfect timing, I'm afraid. I can hear it whirring away.
Yeah.
I'm conscious of just pressing the off button because I don't want to lose the edits I've made to my closing. So I want to just let it think in the background, if that's okay. And obviously I want to read Dr. Bowes' submissions as he's making them so that I can respond quickly in my closing. I would hope 10 minutes would be enough. I am sorry.
No problem. I can imagine the anxiety that that wheel is causing to you at the moment. I hope you don't have to restart your computer and lose it. Hopefully you won't. Oh gosh, that doesn't sound good. Okay.
I have a saved version anyway. It was only minor amendments, so we should it was not the end of the world, but thank you very much, ma'am. Thank you, Dr. Bowes. I'm sorry for.
Okay. Well, I'll give it until 10:30 because we've got plenty of time.
Thank you very much. Thank you.
So I'll adjourn again. Thank you.
Thank you.
So, how did we get on, Mr. Robson?
Yes, thank you very much. All is now well. All I have open is Dr. Bow's closing and my closing, and I'm keeping it to a minimum, so we should limp through. Thank you very much.
All right, thank you.
Okay.
Okay, Dr. Bowes.
Thank you, Madam. You've identified 4 main issues, and we address each of those in turn and then consider whether other material considerations justify granting permission in light of the acknowledged conflict with the development plan. First issue, effect on the character and appearance of the countryside. While by policy CS8 of the core strategy, all new development must have regard to the landscape and its sensitivity to change in accordance with the landscape character assessment. The 2 landscape character assessments upon which the core strategy was based are recorded as the 2006 landscape character assessment, the 2007 fringe assessment. These would have been available for consultation and interrogation during the examination of the core strategy. It was therefore wrong of Mr. Carville to tell the inquiry that the landscape character assessments had not been the subject of detailed scrutiny as a planning policy tool, a point he accepted in his oral evidence. Mr. Carville then suggested that CS8 was not in compliance with the framework because of the sentence which provides that new development will need to enhance the locally distinctive character of the landscape. That argument is flawed on factual and policy grounds. First, it is no part of the Council's case that the scheme should be refused because it fails to enhance the landscape. Rather, the Council's case is that the scheme would fail to preserve the intrinsic character and beauty of the local landscape. The weight to attach to a conflict with the policy requirement to enhance does not arise on the facts of this appeal. Second, and in any event, the Rain Road Inspector was, with respect, simply wrong to observe that a requirement to enhance goes beyond the framework. Paragraph 8C and paragraph 174 provide that the planning system should serve an environmental objective to protect and enhance the natural environment. And third, in any event, it's the Council's evidence that the appeal site forms part of a valued landscape. Here, national policy is explicit that planning decisions should contribute, to and enhance the natural and local environment by protecting and enhancing valued landscapes. Policy CS5 seeks to protect and enhance the landscape character of the countryside by strictly controlling the use of land in the countryside to uses appropriate to the countryside. Mr. Carville suggests that policy is out of date because it seeks to protect the countryside, in reliance of which he relies on the Telford and Wrekin case. The law has, however, moved on from that case, and in DLA delivery, the High Court found that accordingly, in my judgment, it cannot be considered irrational to regard a policy that was designed, as the explanatory text stated, to identify the area beyond the boundaries where development would normally be unacceptable, unless it is for uses compatible with the countryside, as being out of date merely because the framework directs specific protection to greenbelts and valued landscapes, and the planning boundary does not follow the boundaries of those areas. Not only does that case post-date Telford, it was endorsed by Lord Justice Limblom in the Court of Appeal as being correct on that point. It follows that the countryside protection aim of policies RLP2 and CS5 does not render those policies out of date per se. Policy RLP 86 provides that development will not be permitted which would harm the open character of the River Brain corridor. Mr. Carville's reading of the policy was narrow, such that only where development was proposed within the shaded area on the proposals map could there be a conflict with the policy. That is plainly too narrow a reading of the policy. Any development which had the effect of reducing the open character of the river valley would conflict with its terms. Development could reduce the open character by being imposing built form adjacent to the river corridor in a way which reduced its openness. Turning to landscape effects against that policy background, well, the baseline is the appeal site falls within the South Suffolk and North Essex Clayland NCA, A10 Brain River Valley, Area B7 of the fringe analysis, and 7B in the 2015 evaluation. The appeal site and its immediate context is strongly representative and thereby makes a positive contribution to the identified characteristics of those areas. It is set amongst strong networks of rights of way. Pro 21 and 31 are on the eastern side of the River Brain in close proximity to the appeal site. It forms part of a pastoral landscape of intimate small-scale river valley floodplains described as an important landscape attribute. It reveals an undulating steep-sided river valley topography and is a small-scale pastoral river valley landscape. It is part of a pastoral irregular shaped fields which slope down to the valley sides of the river. It has the perceptual quality of being secluded and tranquil, noted as being rare due to the heavy traffic on the surrounding roads and close proximity to Braintree and Witham. And the settlement of Black Notley is on the highest points of the valley sides, leaving the lower valley slopes undeveloped and in pastoral uses. Mr. Holliday's suggestion that grazing of horses is to be treated as different to grazing of sheep or cattle was not founded in the evidence. There was no such distinction in the published character assessments between the types of grazing animals which fall within the scope of the pastoral use. The council submits that pastoral grazing use made of the appeal site brings it within a characteristically pastoral use. That is supported by the full Oxford English Dictionary extract, which provides pastoral as being of land or country, used for pasture, hence of scenery or its features, having the simplicity or natural charm associated with such country. And I just footnote for your interest, madam, that the reference to sheep or cattle farming is said to derive only from the Australian New Zealand usage of the word. So there we are. In its present form and pastoral use, the appeal site accordingly makes an important contribution to the rural setting of Black Notley, recognised in the 2007 Fringe analysis, and reinforces the historic settlement pattern, which has avoided development on the lower valley slopes. Indeed, that characteristic of development on higher ground and the lower valley slopes being undeveloped has a striking consistency across the Brain River Valley, as the annotated OS maps exhibited by Mr. Brown demonstrate. Next, then, on to sensitivity. Well, there's a difference of opinion between the experts, both on value and susceptibility judgments, which feed into their respective overall sensitivity ranking. We say, the appellant says rather, that the local landscape has a median value and is not valued, whereas the council say that the local landscape has a high value and is part of a valued landscape. The approach to determining whether a site is valued for the purposes of 174 of the framework is not defined in the framework. However, in the CEG land case, the High Court told us that the assessment is not confined to the application red line boundary. Rather, the question is whether the site falls within a wider landscape, which is valued. Moreover, both experts directed themselves to the considerations in GLVIA 3 and the Landscape Institute technical notes. We say the key points which demonstrate the site is valued are as follows. Firstly, its distinctiveness. Well, as we've explored, the site sits within an immediate landscape context, which reveals a number of distinctive qualities identified in the landscape character assessments. Mr. Holliday didn't dispute that. Secondly, perceptual. The characteristic pastoral land use and undeveloped nature of the lower valley slopes of the River Brain is easily appreciated from the public footway to the west of the site and from the public rights-of-way to the east of the site. The visibility of the settlement in views from the east is entirely consistent with the character of settlements on the higher valley slopes. The detracting nature of the high voltage lines has been dramatically overstated. With them located on the far eastern side of the railway line, they are therefore in the background and do not constitute a dominant feature in the landscape. Indeed, Mr. Holliday accepted that they did not prevent an appreciation of the characteristic landform and use. Landscape condition. The elements of landform and land use identified remain intact and in good condition. Mr. Holliday was content to accept the landscape features were at least in a fair condition. It is true that at times horticulture can give rise to associated paraphernalia being installed on the land, such as temporary electric fencing, but the same is true for livestock farming, the cows and sheep referred to by Mr. Holliday as being truly pastoral beasts. And finally, recreational value. There's no rights of way which cross the appeal site, but it is adjacent to Coker's Peace, a lottery-funded open space noted for its peaceful pleasure, and plainly cherished by the local community, from which views of the open, undeveloped nature of the appeal site are readily available. Moreover, there are rights of way to the east of the site, which afford views across the appeal site, and Mr. Brown gave evidence that on his visits the routes were well used, which was not challenged, and which you, madam, will note on your site visit, having regard to the clear and worn nature of the paths. When those factors are acknowledged, the site should be seen, we say, as falling within a valued landscape and demonstrating a high landscape value. The appellant says the local landscape has a medium susceptibility to this form of development, and the council says it's moderate to high. Mr. Brown's evidence is to be preferred. The appeal site sits within a landscape which is recognised as having an elevated susceptibility to this form of development. that we're told the skyline of the valley slopes, in particular at the edges of Black Notley, are noted as being particularly sensitive. We're told the strong rural character is noted in giving parcel B7 rise to a medium to high sensitivity. Now, whilst subparcel 7B was assessed in 2015 fringe analysis as having a medium capacity, Mr. Brown's analysis demonstrates that utilising the same methodology, the site should result in a medium to low capacity, equivalent to a medium to high susceptibility. In particular, Mr. Brown lowers the capacity score from 43.5 to 38 because of differences of judgment in the following areas. He was right to do so. On landscape quality and condition, a scoring of D is more appropriate than B, given that reflects even Mr. Holliday's assessment of an area of moderate character in good condition. No party is asserting that the character of the landscape is weak or the condition is poor, which are the requirements for a B scoring. Mr. Holliday accepted the appeal site would not sit totally within B. Openness to a private view. Well, they're very open views, as you'll note, madam, of the landscape parcel from the Brain Valley Avenue. The scoring of E is more appropriate than B. It is perverse to say the parcel is well contained from private views, which is the criterion for a score of B. Mr. Holliday accepted that there are open views from Brain Valley Avenue. Thirdly, the scope to mitigate the development. Well, there's no possibility of mitigating the loss of cross-valley views, the loss of a pastoral land use, the introduction of development into the characteristically undeveloped lower valley slopes, which have been effectively protected for many years, including through the dismissal of a far smaller scheme, the 17 bungalows at appeal in 1990. Accordingly, it is perverse to say that there is good scope to provide mitigation, which is a requirement for a score of B. There is limited scope to mitigate. A score of D is therefore more appropriate. And finally, strength of character and condition. Well, the methodology describes C as the default. It is unexplained why the score was downgraded to B, which deals with the case where a landscape is degraded and in need of enhancement via initiatives. The score of C is therefore more appropriate, and Mr. Holliday, you'll recall, did not disagree. For those reasons, we say the susceptibility of the landscape is moderate to high, which coupled with a high landscape value leads to an overall high sensitivity rating. Turning to effects, we say the overall effects on completion would be major adverse, whereas the appellant submits they would only be moderate, decreasing to minor adverse over time. We say that Mr. Brown's assessment should be preferred. The scheme would transgress almost every one of the landscape character assessment guidelines. In particular, it would not ensure that new built development is in keeping with landscape character. The development would bring built development lower down the valley slopes, developing the characteristically undeveloped lower slopes, contrary to the key characteristics of the character area. Conserve and enhance the landscape setting of settlements. Well, the rural setting of Black Notley would be eroded, as would the open landscape setting of the River Brain. The undeveloped pastoral valley bottom and lower valley slopes would be transformed into built form and managed open space. Mr. Holliday's argument that settlement will have a rural setting because of undeveloped land to the east of the development site was a specious one. That argument, if replicated, would mean that any land identified as contributing to a rural setting of the settlement could be developed, provided there remained undeveloped land beyond. That is plainly wrong and should be rejected. It would not maintain cross-valley views and characteristic views across and along the valley. The development would block views from the west to the rising valley slopes on the other side of the valley. It would also erode views from the east to the presently undeveloped lower valley slopes. Whilst Mr. Holliday suggested there will remain views to the east of the development from the community park, they would not afford the sweep across the descending undeveloped valley slope and to the rising land beyond, which are presently available from Brain Valley Avenue. That experience would be permanently lost. It would not be small scale, there was no dispute about that. It would not respond to the historic settlement pattern. It would depart from the historic settlement pattern of development on the higher valley slopes, descending into the valley. At a local level, it would also be at odds with the prevailing settlement pattern. The prevailing pattern is between 19 to 27 dph, whereas the development is 43. The likely form of buildings to achieve 80 units on 2.6 hectare site would be smaller units or flats, uncharacteristic of the prevailing pattern of detached houses, including bungalows, terraced and semi-detached dwellings. By necessity, gardens would be small and cramped by contrast to the spacious pattern of the development in the area. A number of units on the illustrative layout plan would have gardens below 100 square metres in the Essex Design Guide, with a number of very shallow, if any, front gardens. The attempt by the appellants to meet the requirements of the latest iteration of the framework for tree-lined streets would be half-hearted, with trees only sporadically placed along one side of many of proposed roads, thereby further demonstrating the cramped nature of up to 80 dwellings on the reduced developable site area. This cannot be characterised as a high standard of layout and design which, quotes, reflects or enhance local distinctiveness, and consequently there is a breach of RLP 90. Turning to visual effects, which form an important part of the evaluation of the impact on the development on the character and appearance of the area. The key points are as follows. Well, from the west, the appellant concedes there would be at least a major moderate effect on completion for sectors along Brain Valley Avenue. Whilst these are characterised as residential users, it's important to recall that Brain Valley Avenue is a public highway to which the general public have a right of access. It would be a mistake to characterise these as private views. The appellant suggests the effects will diminish to moderate adverse in 15 years due to the effect of boundary planting. That is wrong. Presently, an undisturbed view is afforded across the valley, revealing characteristic undeveloped pastoral lower valley slopes. The development will permanently remove the ability to appreciate that cross-valley view and reduce the openness of the river corridor. Whether the view is obscured by the housing or by screen planting, the effect will be the same and it will be adverse. A fairer judgment will be that the effects on completion remain the same. From the east, views available from the footpath 21, there are also views from footpath 31 further east, which rises up the opposite side of the valley. Those views allow a clear appreciation of the characteristic vegetated valley bottom, the undeveloped pastoral lower valley slopes, and the settlement on the higher valley slopes. The development would disrupt that characteristic view by bringing development down the valley to the lower valley slopes. The appellant accepts a moderate adverse during construction. Mr. Brown's evidence was that moderate adverse was an appropriate score in perpetuity. He was right. There would be no amount of mitigation which would reverse the loss of that characteristic view. A moderate adverse effect is a fairer score. And finally, from the south, from Coker's Piece, there are views available to the appeal side from the north, which afford an appreciation of the characteristic undeveloped and pastoral lower valley slopes available. The development would undermine the perception of Coker's Piece being part of the undeveloped river corridor, separate from the settlement edge. The appellant identifies a moderate adverse effect during construction, and Mr. Brown suggests that will remain moderate, irrespective of mitigation. The views will either be disturbed by housing or screen planting. Either way, the view of undeveloped lower valley slope is lost. Overall, then, the development is plainly in conflict with the relevant development plan policies, as it fails to, quote, have regard to the character of the landscape and its sensitivity to change, or be in accordance with the landscape character assessment. Moreover, it is detrimental to the distinctive landscape features of the area and will not successfully integrate into the local landscape, nor protect and enhance the landscape character and amenity of the countryside. Indeed, so much appears to be common ground, as Mr. Carville expressly acknowledges a breach of policies CS8, 5 and RLP 80. That must surely follow from the appellant's LVA, which identifies as moderate adverse effect on the site in its immediate context. Mr. Carville did not accept, however, a breach of RLP 86 because the built form would be outside the area shaded on the proposal's map. Plainly, RLP 86 plainly, however, contemplates development outside the river valley area, which affects its openness. Here, the council submits the development outside the area will reduce the open character of the river valley when experienced from public rights of way. To that extent, there is a breach of RLP 86 too. Finally, all that is entirely consistent with the findings of the Secretary of State on the 5th of April 1990 that inserting 17 bungalows onto the appeal site would be detrimental to the open character of the countryside around the village and the scenic quality of the valley. Mr. Carville accepted this was a material consideration, and there was no evidence before the inquiry to substantiate the point that the situation on site had changed materially since that decision. Issue 2, adequate access to open space. Council accepts that adequate amenity space could be provided without recourse to the community park. However, the council disputes the community park will present a benefit of anything more than limited weight for 2 reasons. First, it is mostly in flood zone 3A. As Mr. Tibbetts' evidence, the site would not therefore be likely available for recreation all year round. And secondly, the park has a lack of natural surveillance as a consequence of the proposed trees and hedging that would separate it from the housing development. The third issue then, access to day-to-day services by sustainable transport modes. Or Black Notley is at the lowest tier of the settlement hierarchy as another village, it remains at the bottom of the settlement hierarchy in the emerging local plan part 2. Policy CS7 requires that new development be located in accessible locations to reduce the need to travel. The framework is clear that significant developments such as this should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. First priority is to be given to pedestrian cycle movements, and facilitation to high quality public transport should be achieved. The emphasis is therefore on changing behaviour, not simply having available the ability to travel without using a private car. A critical analysis of the attractiveness of a route is therefore necessary before concluding the policy obligations are met. Well, is the policy obligation met? It's common ground that future residents would need to leave Black Notley to meet their day-to-day needs. Access on foot to Braintree's shops, leisure and services all far exceed the preferred maximum of 1.2 kilometres walking distance. Access to the John Ray infant and junior schools is within the preferred maximum distance of 2 kilometres from the site access, but it exceeds the walkable neighbourhood distance of 800 metres in Manual Streets. Even with the proposed footway improvements, the route would not be within the recommended 2 metre width for its length, contrary to the guidance in Manual for Streets. It is well established that acceptable walking distances are context specific and that, quotes, general deference to walking, such as the attractiveness of the route, may affect take-up in the CHIT guidance. The Council therefore submits that the route is unlikely to present a likely walking option, even with the improvement works. Whilst there is a bus stop within the recommended 400 metres from the site, the service does not tie in with the beginning and end of the school day for the infant and junior schools. Parents of children of primary age, it is more likely than not that they will drive. This has been demonstrated by the National Transport Survey cited within the appellant's accessibility statement, which found that for trips between 1 and 2 miles, 19% of primary education trips are on foot. Cressing railway station is 1.2 kilometres from the site, which offers 1 train an hour to Witham and Braintree. However, it has a small car park with only 12 spaces and 6 cycle spaces. Moreover, it is only accessible via Bulford Lane, a narrow single-track unlit road with blind bends, and which is also liable, to flooding. While cycling does provide a realistic option to car travel for journeys under 5 kilometres in general, that does not account for the attractiveness of the route. The road between Braintree and Black Notley is 40 miles an hour, which Mr Tibby considers would be unlikely to be attractive to children or cyclists lacking confidence. The same goes for Church Road, Baker's Lane, which connects the village to the garden settlement of Great Notley. For those reasons, reliance on a private car is likely for most trips made by future occupiers. There's therefore a conflict with CS7, the core strategy and the framework. Planning balance overall then, it's common ground the scheme fails to accord with policies CS8, CS5, RLP2 and RLP80. Council say the scheme also conflicts with RLP86 and 90. It's common ground the scheme fails to accord therefore with the development plan as a whole. Starting point, therefore, is that planning permission should be refused unless other material considerations justify deciding this application, otherwise in accordance with the development plan. Well, is the tilted balance engaged? The tilted balance at para 11 of the framework applies either where there are no relevant development policies, which is not said here, or where the policies most important for determining the application are out of date. There is no other basis on which the tilted balance can be applied. Mr Carville's 3 reasons why the tilted balance was engaged on the facts of this appeal were wrong on the law and the facts. Firstly, he says the policies for which the council seeks to refuse development relate to an out-of-date housing requirement. That's plainly wrong. Firstly, the Court of Appeal has now decided in Peel at paragraph 65 that the expiry of the plan period does not render the policies out of date. Secondly, the Court of Appeal found in Daventry that the new framework basis for determining housing needs, i.e. full objectively assessed needs, related to plan making and not to decision taking, that where a planning authority was meeting a 5-year supply against the full objectively assessed needs, the relevant development plan policies were not to be treated as out of date simply because they were adopted against a previous approach to calculating housing needs. The Court of Appeal rejected the submission that this was a situation where a policy is overtaken by more recent policy. Third, the fact that policies were adopted against needs set out in the now revoked structure plan and regional strategy was also found not to be relevant to whether they are out of date. See Daventry at paragraph 42. Now, madam, I think you're going to be treated to another authority by my learned friend, which he was good enough to give me advance warning of. So I've preemptively dealt with it, but you don't have the document yet. So you'll marry the two up when you get them. Mrs. Justice Lang does not say anything to the contrary in Wokingham, which is the case my learned friend wants to draw your attention to, at paragraph 60, for three reasons. First of all, the issue in that case was not about whether the relevant policies, CP9, CP11 and CCO2, were out of date, rather whether the conflict with those policies should have carried full weight instead of significant weight. So it was a very different situation. Secondly, the judge did not therefore say that a policy being adopted against the now superseded housing requirement rendered the policies out of date, because that just wasn't an issue before the judge. And indeed, it would have been quite peculiar had she said that, because for two reasons. One, because Mrs. Justice Lang was the judge in Daventry at first instance, which she concluded to the contrary. And secondly, she herself cited the Court of Appeal's decision in Daventry, where her judgment was upheld, and she cites the very paragraph where they reject that point. So that doesn't really take matters much further, I say. Fourthly, nowhere in the framework is such a proposition to be found, and taken to its conclusion, it would lead to the absurd situation whereby a policy was consistent with the framework and there was a 5-year land supply, but the tilted balance would still be engaged simply because of the historical fact that the policy was adopted against the now superseded housing requirement. But when confronted with that mad conclusion of his thesis, Mr. Carville appeared to back away from this point as being a freestanding basis on which the tilted balance would be engaged. Finally, whilst this point appears to have found favour in the Gilder Terrace decision, it appears the Daventry judgment was not drawn to that inspector's attention, and moreover it appears the inspector did not grapple with the natural conclusion of the point. It follows that to find policy RLP2 or CS5, or indeed any other policies, on the above basis to be out of date, that should say, sorry, on the above basis would not be sound. Secondly, Mr. Carville says the tilted balance is engaged because, quotes, policies relating to the countryside are out of date. However, even if he was right, which for the reasons I dealt with earlier, he's not, the fact that one or two policies are out of date does not engage the tilted balance. It's only where the most important for determining the application are taken overall out of date is the tilted balance engaged, and that's dealt with now conclusively by the Court of Appeal in the Paul Newman case, and not disputed, I understand. Mr. Tivy says the basket of most important policies embraces all of those ones, and on the appellant's case, only two of those policies are out of date. It follows that even on the appellant's case, the tilted balance is not engaged on this basis. And finally, Mr. Carville says the tilted balance is engaged because there is no 5-year land supply on the basis of the Earl's Cone decision. Well, in principle, of course, a lack of a 5-year supply is a basis on which the tilted balance can be engaged in a housing application. Here, however, that should not be the conclusion. My apologies. That should not be the conclusion for a number of reasons. Firstly, the council has supplied cogent reasons why the conclusions the Earl's Cone inspector arrived at on the evidence before her would no longer be justified. Only two of the sites were now said by the developer not to be deliverable within the 5 years. That's the land east of Broad Road and land at Towerlands. On both, there is new material before you, which amply justifies taking a different view. Firstly, on the Broad Road case site, the new material before this inquiry, not before the Earl's Cone inspector, is the updated trajectory from L&Q. And on Towerlands, the new material before you, madam, not before the previous inspector, is the submission of a reserved matters application. Secondly, there was agreement that emails and pro formas in principle could be relied upon to demonstrate clear evidence of deliverability. That was the conclusion of Inspector Ware in the Williams Ford Road appeal. Moreover, we do not know what evidence was before Inspector Stevens in the Sonning Lane Common decision that Mr. Carville relied upon. But there's certainly no evidence before this appeal to demonstrate that those completing the pro formas were, quotes, incentivised to reduce completion by optimistically forecasting delivery of housing from their own sites. And finally, the rebuttal proof of Cathy Carpenter provides, we say, a clear basis to conclude the council can demonstrate a 5-year supply of housing sites. And for all those reasons, we say the tilted balance is not engaged, and the application should be approached in a normal way. Mr. Carville accepted that where the tilted balance is not engaged, the development plan is to be taken as up to date. So turning to the harms, policy harms, this is a case where paragraph 12 of the framework applies. It provides that where a planning application conflicts with an up-to-date development plan, permission should not usually be granted. Moreover, at paragraph 15 of the framework, the government emphasises that the system should be genuinely plan-led. Accordingly, departing from an up-to-date plan is harmful in and of itself. And that's supported by what Lord Justice Sales said in Daventry, paragraph 44. He said, since an important set of policies in the framework is to encourage plan-led decision-making in the interests of coherent and properly targeted sustainable development in the local authorities area, significant weight should be given to the general public interest in having plan-led planning decisions, even if particular policies in the development plan might be old. There may still be a consideration benefit in directing decision-making according to a coherent set of plan policies, even though they're old, rather than having no coherent plan-led approach at all. And we would adopt and commend that approach to you, Madam. Mr. Carville suggested that if there was a 5-year land supply, the weight to attach to settlement boundary policies, RLP2 and CS5, should be limited because the 5-year supply relies upon schemes coming forward in breach of those policies. Mr. Carville derived support for that proposition from the Rame Road inspector, and with respect to Mr. Carville and Inspector Price, that argument is totally misconceived. Regrettably, it appears that Inspector Price was also not shown the Court of Appeal's decision in Daventry, where this point was expressly considered and rejected as unsustainable. And Lord Justice Sales says the fact that the council is able to show that with current saved housing policies in place, it has the requisite 5-year supply, tends to show there is no compelling pressure by reason of unmet housing need, which requires those policies to be overridden in the present case. It follows that Mr. Tivey was right to afford moderate weight to the conflict with the settlement boundary policies, and did Mr. Carville agree that moderate weight should be afforded to what he termed harm to the plan-led system if there was a 5-year supply, and we agree with him. Car dependency, the framework encourages a shift towards sustainable modes of transport. Mr. Carville accepted that an inspector should critically analyse the likelihood of sustainable transport modes being taken up. Because Mr. Tivey says there is not a likelihood of sustainable transport modes being taken up because of their attractiveness or lack of, there is a failure to comply with national policy, even if the scheme is within the distances cited in the supporting text to policy CS7. Mr. Tivey was right to afford significant weight to that harm. It's harm to the character and appearance of the area, which in the council's case, the appeals site lies in the valued landscape, and accordingly acknowledged conflict with policies CS5 and CS8 should, even on Mr. Carville's analysis, carry significant weight if that's correct. Even if the landscape is not found to be valued within the meaning of the framework, it is still countryside, which reveals intrinsic beauty, which is to be recognised in the planning balance. There is still the harm to the open character of the Brain River Valley, specifically protected by RLP 86. And finally, there is the uncharacteristic form and pattern of development, which will be necessary consequence of the outline permission parameters. Whichever way it's viewed, the harm to the character or appearance of the area should carry significant weight. Turning to the benefits, market housing. If the council are right, it can demonstrate a 5-year supply of housing sites. There is no logical reason to attach significant weight to the provision of market housing. If that were so, harmful development would be able to come forward outside the plan-led system. Mr. Tivey was therefore right to afford the provision of 80 units, moderate weight. Mr. Carville's argument for continuing to give significant weight to the benefit of new housing, even if there were to be a 5-year supply, because of the need to account for sites not coming forward, that was misconceived. The whole point of the buffer is to account for that uncertainty. No weight should be attached to the invitation to impose a shorter reserve matters and implementation condition. There was no evidence from the house builders that they would be content to accept such a short condition, bearing in mind the extensive lead-in times to design a fully policy-compliant detailed scheme. There is no possibility to extend compliance with such conditions. And Madam, you'll know that Section 73, subsection 5 of the Town and Country Planning Act expressly prohibits the extension of the submission of a reserved matters condition time limit or the implementation time limit. So unwittingly, the shorter condition may lead to the situation whereby there is insufficient time for the house builder to submit the relevant reserve matters and implement the scheme, leaving the permission to lapse, and ironically having a knock-on effect upon housing land supply. In the absence of evidence from house builders of being content with that short timetable, no weight should be attached to this shorter timetable. Affordable housing is now common ground that should carry significant weight. The economic benefits should carry moderate weight in light of the fact that housing can be delivered with the scheme, the same economic benefits in Braintree to meet the needs without the associated harms. Design and landscaping, well, an appropriate landscape scheme is a basic policy requirement. It is not a matter which should carry weight. The agricultural buildings on the site are consistent with the pastoral character of the valley bottom and lower slopes. Their removal is not a benefit. No weight should be attached to the satisfaction of a basic policy requirement. Public open space, for the reasons set out, the council does not consider the open space would be attractive due to the likelihood of it being unsuitable for the sum of the year and lack of surveillance, and in the circumstances Mr Tibby was right to afford it only limited weight. Biodiversity, well, the framework requires that development deliver net gains, and the Environment Act will require 10% to be delivered when it comes into force. No great weight should be attached to the projected 10% net gain here. So overall, on a flat balance, there is no sensible room for doubt that the benefits advanced in favour of the scheme cannot outweigh the conflict with the development plan. They could be replicated anywhere, at any time. To give licence to such a laissez-faire approach to land use planning would be to caustically erode confidence in the plan-led system. However, even if the appellant is right to say the council's land supply is 4.96 years, Mr Tivy was quite clear that the adverse consequences of the scheme would clearly outweigh the benefits in that context. He was right to do so for the following reasons. A 4.96 years land supply equates to a 39 unit shortfall. It is by any standard small. The council has a positive track record of delivery demonstrated by its housing delivery test results. Even since the Earls Colne decision, the position is apparently improving, given that Mr Carville has found more deliverable units than the Earls Colne inspector, and the shortfall is likely to be made up quickly by the extant capacity in identified sites or the local plan part 2 site allocations document. So to draw all that together, it's common ground the scheme conflicts from the development plan, and it's agreed that there will be non-compliance with RRP 280, CS5 and 8. The council say the breach extends beyond that to 8690 SP3. If the council's land supply evidence is accepted, the scheme cannot hope to provide a compelling basis to depart from the plan, even ignoring the council's case that the extent of the departure from the plan ranges wider. If, however, you, madam, were to consider the land supply to be at 4.96 years, as the appellant says, the council accepts the tilted balance will be engaged. However, the council submit that even then the significant harms arising from car dependency and the impact on the character and appearance of the area significantly and demonstrably outweigh the benefits. On either analysis, the Planning Commission should clearly be withheld for this speculative and harmful scheme. Thank you.
Thank you, Dr. Bowes. Mr. Robson, it's your turn now. I haven't received it. I don't know whether you've sent it or not.
Sorry, ma'am, I haven't. I'm just putting in, rather than making notes or asking you to make manuscript notes on my responses to Dr. Bowes' submissions, I'm just adding them in now on Word. Perhaps if we take 5 minutes for a comfort break whilst I save the document and send it across. You should have it with no need to take manuscript notes.
Okay, that's great. Okay, well, we'll come back because it's got to be sent to me as well. I don't know whether who's at their computers or in their office. So we'll come back at 11:20, please.
Thank you, ma'am.
Okay, thank you. Hello, Mr. Robson. I was just messaging my case officer and he's just sent your closing
Right,
through.
Mum.
Thank
Great,
you.
thank you.
Oh,
Is Dr.
I'm
Bowes?
just going to, sorry?
I was just checking if Dr. Bowes was there. He is. There we go.
I'm just opening the email. It has literally come through this
Thank you.
second, so I'm just opening it now.
Mum, there are two documents attached. One is the closing submissions, and the other one I've headed, perhaps rather grandly, in hindsight, legal submissions. All I seek to do in that legal submissions document is direct you to relevant paragraphs and my submissions on how the cases should be interpreted, because that avoids me, frankly, going to lots of bits of case law in closing submissions. I'll just deal with the conclusions, and you can go back and look at the origins in the legal submissions document. I did notify my learned friend yesterday of the one additional case, Wokingham, which he addressed in his closing. So none of this came as a surprise to, or should come as a surprise to, my learned friend.
Okay, and he's not jumping up to say anything, so that's,
Unless his camera doesn't work, but I'm assuming he's content. Oh,
No, that's fine. That's fine.
thank you, Dr. Bowes.
all right. Thank you.
Ma'am, you identified three main issues at the CMC and adding a fourth at the opening of the inquiry. Those main issues relate to the character and appearance of the countryside, whether future occupiers would have adequate access to open space, whether the development would be in a suitable location for access to day-to-day service by sustainable modes, and whether or not the council can demonstrate a 5-year supply, and I will take those in turn. The character and appearance of the countryside. The appeal site is in an edge of settlement location. It abuts Brain Valley Avenue on its western boundary. The properties along Brain Valley Avenue sit further up the slope that forms the shallow western side of the Brain River Valley. It is apparent when Black Notley is viewed from the eastern slopes of the valley, and the reference there to the viewpoints in Gary Holiday, GH Proof of Evidence, and BB, Bobby Brown, Mr. Brown, it's a rebuttal. When Black Notley is viewed from the eastern slopes of the valley, that one is looking across the valley at the edge of the settlement. As agreed with Mr. Brown in cross-examination, there is at least 4 rows of housing that can be seen on the rising slopes of the valley side. It is therefore an important and highly noticeable characteristic of the Western Valley slopes that there is a considerable amount of residential development. In response to a series of questions in cross-examination, Mr. Holiday was clear that the experience of the viewer when looking across the valley towards Black Notley from those eastern slopes is one of looking at the edge of the settlement. The other main characteristics of the view being the river and the riverine trees and vegetation, neither of which are affected by the development. Ma'am, you will appreciate this on site, of course, and it is manifestly not an experience where the eye is magnetised by the parcels of land onto which the built development will go. In fact, those parcels are barely seen at all, and where they are, they read as part of the settlement. The starting point is an assessment of the landscape baseline, and in this regard, there is very little between the experienced landscape experts, Mr. Holiday, Jill Wynne-Williams of Wynne-Williams Associates, Mr. Brown's boss, the Landscape Partnership, and Chris Blanford Associates. Unfortunately, Mr. Brown found himself disagreeing with much of the weight of experienced expert analysis, stretching back longer than his career as a landscape architect. The baseline documents look from the widest lens, the national character area, down to the finest grain analysis of the landscape in the most recent and most up-to-date assessment in the 2015 fringe analysis. From those documents, it is agreed that the NCA assessment necessarily looks at the landscape in generalised terms. As Mr. Holiday rightly stated in cross-examination, it is therefore not surprising that the appeal site and the surrounding landscape exhibits some of the characteristics identified in the NCA, for example, a river valley. It is a stretch in the extreme, as Dr. Bowes seemed to do in cross-examination of Mr. Holiday and in his closing, to suggest that because the site and its context demonstrates some of the generalised characteristics of the NCA, that its landscape value greatly increases. Much time was spent, you'll recall, with Mr. Holiday about the importance of the NCA places on protecting pastoral river valley landscapes. Whilst a fantastic discussion that exposed that neither council would make good farmers, it was ultimately pointless, since the definition in the small OED of pastoral covers the grazing of sheep and cows. The focus of the definitions from the full-sized OED, introduced by Dr. Bowes in closing, is of or pertaining to shepherds or their occupation. Like Dr. Bowes, I am not a horsey person, but I am confident that a shepherd and their occupation is concerned with sheep rather than horses. This takes his point no further. If AB seeks to rely, sorry, there's a typo there, it should just start if AB, such can go. If AB seeks, Dr. Bowes seeks to rely on the part of the definition of pastoral in the OED relating to of land or country used for pasture, hence of scenery or its features having the simplicity or natural charm associated with such country, as he did in closing, then I'm afraid this is also unhelpful to the local planning authority. Pasture land is for the grazing of sheep and cows. Even if it were taken to include grazing horses, that activity is not one of simplicity or natural charm, as the OED states, because the NCA rightly notes that equestrian use is a landscape detractor. Thus, whilst the NCA does seek to protect the pastoral river valley landscape in general terms, the river valley landscape of the appeal site is not in pastoral use, it is in equestrian use. The Essex County Landscape Character Assessment zooms in from the NCA to the Blackwater, Brain and Lower Chelmer valleys. At this level of focus, the landscape is of low sensitivity to small urban extensions of under 5 hectares, and it was conceded by Mr. Brown in cross-examination that this site is a small urban extension because only 2.06 hectares will hold residential development, with 3.88 hectares not. The most sensitive points would be unaffected by the development. The integrity of the valley floor is maintained as it will be undeveloped, and the cross-valley views are unaffected and reference there to the relevant viewpoints. The 2006 LCA looks just at the Brain River Valley landscape. The development is in accordance with the planning guidelines. It is in keeping with the existing landscape characteristics, being development on the valley sides. The setting of Black Notley will be preserved because the site already reads as part of the settlement. And in that regard, see the assessment of the 2015 fringe assessment at CD 8.13. And cross-valley views are maintained. There is no harm to the landscape at this level. The most recent fringe assessment in 2015 is the most granular of the assessments. From that, a number of key points emerge. The site is within a parcel of land that is enclosed by dense hedgerow and tree belts, and there are no proposals to remove the dense hedgerow within the site or any of the riverine vegetation. A parcel of land that is closely associated with the settlement edge. It is a parcel of land that has a moderate scope for development, and it is in the top 25% of sites in the Black Notley area for development. It was incorrect of Mr. Brown then to assert that there are less harmful sites. This site is one of the best placed to bring forward development. Drawing all of this together, the site is of moderate and not high sensitivity. The two fields proposed for development have strong associations with the existing urban edge and feel more associated with the settlement than the countryside, a point agreed between Mr. Holliday and the 2015 fringe assessment. Whilst the wider landscape studies conclude a higher sensitivity, they are looking at a much wider landscape, which will include areas of much higher sensitivity than this site. Indeed, as you can see from the fringe assessment itself, ma'am. The development is in accordance with the LCA planning guidelines, and the effects of the development are localised only, causing only minor adverse or negligible effects 15 years from completion. At a site level, the effect will be minor adverse at 15 years once mitigation is established. This is because the residential development fits with the existing topography and the grain of the development. The internal vegetation and river vegetation are maintained and provide screening, and with 65% of the site given over to green infrastructure, it is a well-conceived development in an area of this landscape most capable of receiving development, overdevelopment in that sentence, certainly. Finally, Mr. Brown and Dr. Bowes pursued the point that this development would be partly within the 40-metre contour, Mr. Brown's green finger. There is no policy support for this approach. There is no landscape assessment that says do not construct below the 40-metre contour. Yes, the appeal scheme may be within Mr. Brown's green finger, but so what? There is no distinguishable landscape feature at 40 metres within the site, and no policy support for this approach. It is totally irrelevant, and Ma'am assists you not at all. When it comes to the visual effects, this will of course be appreciated on site. However, it must be recorded that the LPA is taking a wholly myopic approach to visual impact. Stood next to the site, the viewer will see residential development where there is currently none. This cannot be avoided if homes are to be built. The approach from Dr. Bowes and Mr. Brown urged assessment to stop there. If a decision maker were to ask itself only if development could be seen, and even if only when stood next to it, then no houses would be built. The question is, what is the visual effect of this development from a range of the most sensitive viewpoints? On that approach, views from Brain Valley Avenue and private residences will be lost. However, New Cross Valley views will become available from the community park. The view Mr. Brown goes to in Coker's piece cannot show the built development that is next to the green space and influencing it. The views from the footpath next to the river towards the development are heavily filtered by the internal hedgerow, and the views are already influenced by the built development on the higher ground. Overall, the visual impacts are localised and limited to the immediate surroundings of the site, as one would expect if buildings are to go there. The council's valued landscape case was noticeably weak. It is clear to see that this is not a valued landscape. Mr. Brown's partial assessment, excluding factors of value which this site does not demonstrate, should be given very short shrift. The assessment from his boss at the consultation phase of the application did not conclude the site is part of a valued landscape. It was noticeable how Mr. Brown desperately attempted to avoid the question by insisting that his boss's instructions did not require an assessment of value, despite those instructions being to provide an independent assessment of the landscape and visual impacts of the proposed development. If his boss thought this was a valued landscape, it is inconceivable that it would not have been mentioned. In reality, it is not clear where the inclusion of valued landscape in the reason for refusal come from. The clear-eyed and complete evidence of Mr. Holliday on this issue must be preferred with a reference to where you can find it. This is quite simply not a valued landscape. Adequate access to open space. The density point was not pursued with any great vigour by the LPA in their oral evidence or in the cross-examination of the appellant's witnesses, perhaps a tacit admission of a weak point. Fundamentally, this is an issue for reserved matters. The indicative layout is precisely that. It is not the final layout of the development. When it comes to the reserved matters, the LPA can consider the design Essex Design Guide. When it gets to that stage, an assessment of the garden provision will be influenced by a number of factors as set out in that guide. The size of the property, the proximity to the open space, the role the property plays in the layout of the scheme. Finally, on access to open space, the residents of the scheme will have access to the community park and Coker's piece. The open space provision is, by size, greater than is required by policy. The residents will have more than ample open space to enjoy the fresh air. Ma'am, I'm sorry, I was hoping to help to save your hand, but there is something that I need to add in there. Ma'am, you'll recall that we went to Annex 3 of the NPPF, which identifies amenity open space as compatible development in a flood zone. Therefore, the framework is no barrier to open space being provided in this location and should not diminish the importance of the community park. Apologies, ma'am, there's always something. Finally, for completeness, the proposed density of 39 dpa, as shown in the illustrative master plan, is not incongruous with the existing developments in Black Notley, particularly the most recent development at Mary Rook Way at 36.6 dph. To be a development noted for its design in the 2018 Essex Design Guide. The reality, as Mr. Holliday noted in his oral evidence, is that density in the layout of schemes has evolved since the Brain Valley Avenue development. New development should not seek to replicate what is already there in layout or, frankly, design. If we followed the approach urged upon Mr. Holliday by Dr. Bowes, we would live in a drab world that did not evolve with the needs and tastes of those that live in it. Density is a matter for reserve matters and is not a reason for refusal. There is no evidence at all that before this inquiry that a scheme for 80 units cannot come forward on this site in principle at an acceptable density. Finally, briefly, tree-lined streets is also a matter that can be secured at reserve matters. Accessibility. There are a number of very important agreements between the local authority and the appellant on this matter. The development plan defines an accessible location in the justifying text of policy CS7. Accessible locations will be defined as within 30 minutes walking or cycling distance of a retail centre, primary school, secondary school or GP surgery. The definition is then given the weight of policy by inclusion of the terms accessible location in the body of CS7. The walking and cycling isochrone plans show that the primary and secondary schools are within 30 minutes walk, applying 400 metres in 5 minutes from the CIHT guidance. The retail centres and GPs in Great Notley and Braintree are accessible by bike. On the council's own evidence, Black Notley is a sustainable and accessible location. The existing bus service is a very high standard indeed. There are half-hourly buses into Braintree to fit in with the school times. This compares extraordinarily well with other settlements in the village tier, where the core strategy notes that almost 30 villages have less than one bus per week to their local centre. There is no issue with the safety of the proposed walk from the site to the schools. The works to the proposed footpaths are an improvement, as Mr Tivy agreed. They will not conflict with the manual for streets guidance. The local highways authority agree that there are, quote, opportunities for those travelling to and from the proposal site to do so by more sustainable modes of transport, such as public transport, cycling and walking. The development complies with policy CS7 and it was agreed to comply by Mr Tivy. This is the only sustainable transport policy referred to in the reason for refusal.
Madam, I'm sorry to interrupt, but it is, I hope, helpful. I forgot to delete paragraph 42 of my closing, the assertion that there was a conflict with CS7, because as Mr Robson has quite rightly identified, my witness accepted that that policy was met. That is a failure on my part of oversight, because I write the closings in advance, and they don't always marry up with what happens. So to save him reading out that paragraph, please forgive me for interrupting him, but I hope that that's a helpful point of clarification.
Thank you. No, that is very helpful, and I'm amazed that you managed to write your closings in advance. That's a staggering degree of organisation. That might be my New Year's resolution.
Thank you.
Thank you, Dr. Bose. Ma'am, in that case, I think it would probably be sensible to cross out from even AB did not seek to go behind. No, we'll leave that in. And let's cross that out. Even AB did not seek to go behind this in re-examination through to the end of that paragraph, as it's agreed now that CS7 is not breached. Thank you, Dr. Bose. The sole issue that the LPA advanced in oral evidence was that the walk between the site and the primary school, noting no issue was raised about the secondary school pupils, with a parent with 2 children, one in a pushchair and potentially with another on a scooter. This extreme example is no way to judge accessibility of a site. Desirability of a walking route is a matter of individual choice. All the developer can do is ensure that the route is safe, there is no dispute that it is, that destinations are within guideline distances, they are on the council's own definition, and that travel plans encourage sustainable transport, and that will be delivered through the conditions. In summary, ma'am, Black Notley is a sustainable location with a range of different sustainable transport options. 5-year supply. Ma'am, you can only reach a conclusion on the 5-year supply on the basis of the evidence that is before you. It is totally insufficient to make oral statements without any evidence to back them up, as Miss Carpenter did at times. That certainly cannot amount to the clear evidence required by the framework. The whole purpose of the amendment to the definition of deliverable was to avoid undue weight being given to unsupported statements from councils that outline sites would contribute to the supply. The new ISH test is rightly more rigorous and demanding of councils. There is no dispute about the housing requirement of 5,352. The issue between the LPA and the appellant relates to the number of houses that will come from two specific sites, land east of Broad Road and Towerlands Park, to contribute to the supply. The test for deliverable sites is well established in the definition of deliverable in the MPPF, and specifically for the two sites in question, where a site has outline planning permission for major development, has been allocated in a development plan, has a grant of permission in principle, or is identified on a brownfield register, it should only be considered deliverable where there is clear evidence that housing completions will begin on site within 5 years. It is about the clear evidence that sites will come forward, not the certainty that sites will come forward. Forecasting is an exercise fraught with uncertainty. It would be impossible to forecast with certainty that X number of houses would come forward. That is readily understood by the appellant and is not its case. It is the appellant's case that the clear evidence is not there that these two sites will contribute to the supply. What amounts to clear evidence is a matter of planning judgment for you, ma'am. The appellant is not saying that pro formas cannot per se amount to clear evidence. A pro forma is, after all, just a form. What matters is the information contained in it, the source of that information, the detail provided, the date of the information, and the history of the ability to collect reliable information through it. Some of the doubts about the information contained in pro forma responses was expressed by the inspector in the Sonning Lane Common Appeal, and I quote there from that decision. It is for the LPA to produce the clear evidence that shows the two disputed sites will contribute to the supply. That clear evidence that is certainly not clear evidence that the site will deliver houses. The design guide is not new. It is part of the outline permission and is one of the approved plans. This does not show progress since the Earls Colne decision. The submitted pro forma, the only documentary evidence to back up assertions from the council, says it is unknown how many house builders will be on site, and the pro forma was completed by the land promotion company L&Q. The inquiry was told that negotiations were underway with a house builder to buy an unknown phase of the site. Negotiations can fail and negotiations can drag on. There is no clear evidence of a house builder buying this site. There is no evidence of who will deliver the supporting infrastructure or by when. Ma'am, there is no clear evidence that this site will contribute anything to the supply, let alone the 270 that the council seeks. Towerlands Park. The appellant argues that only 50 units from this site should be included in the supply, and the council argues for 155. The issue with this site is exposed in the pro forma on which the LPA seek to rely. Section 3 of that document. There's a sign that I write my closings at 2 o'clock in the morning and not like Dr. Bowes before the inquiry. The issue with the site is exposed in the pro forma on which the LPA seek to rely in section 3 of the pro forma. It shouldn't be a sentence on its own as it doesn't have a doesn't have the necessary components of a functioning sentence, frankly. Only 50 units from this site can be occupied until a link road is put in place. The developers of the Towerlands Park site are not in control of delivering the link road. There is no evidence whatsoever produced by the LPA to say when this link road is coming forward. There was some speculation from Ms Carpenter and Mr Jones, but that is not enough. As Mr Carville rightly pointed out in the round table, a developer will not build houses that cannot be sold for occupation. Why incur the costs with no guarantee when there will be a return? If the link road is not in place, the developer will not go past should be past PAST 50 units. There is no evidence of when the link road will be built, allowing more units to be occupied, and only 50 should be included in the supply from this site. The final calculation. In total, 375 units should be deducted from the council's claimed supply of 5,688. Against the requirement of 5,352, this leaves a 5-year supply of 4.96 years. In the Earls Colne decision from the 12th of November this year, Inspector Sabu found a 5-year supply of between 4.7 and 4.9 years. There has been some progress since then, as Mr Carville acknowledges. However, there has been no progress on the two disputed sites, and the council still cannot demonstrate a 5-year supply. Planning balance, ma'am, dealing first with the tilted balance. It was agreed with Mr Tivy in cross-examination that there are a number of gateways into the tilted balance in paragraph 11. A failure by the LPA to demonstrate a 5-year supply, as set out above, the council does not have a 5-year supply, and where the policies are most important to the determination of the appeal are out of date. It is only necessary for one of these gateways to be open for the tilted balance to be engaged. In this case, both gateways are open. It is important, ma'am, that there is clarity on which are the most important policies for the determination of the appeal and what makes a policy out of date. Fortunately, both these issues have been the subject of litigation and there has been clarity from the courts. And there I refer you, ma'am, to the legal submissions. The decision as to whether or not a given policy is or is not out of date is a question of judgment for the decision maker, provided that proper regard has been had to the relevant guidance. Policies can be out of date for a variety of reasons, such as where they have been overtaken by events. It is a rational conclusion that settlement boundary policies based upon superseded housing requirement figures are out of date. This is, quote, not analogous to deciding that the policies are out of date merely on the basis of their chronological age. This includes, but is not limited to, the conformity of a local plan with the framework. For the purposes of paragraph 11D, the decision maker must first decide which policy or policies are most important to the decision, then assess whether that basket of policies, when taken together, is out of date. This too requires an application of a planning judgment with which the court will be slow to interfere. When assessing which policies go into the basket, it was agreed by Mr. Tivy in cross-examination that this was only the policies with which a development conflicts. As is established, the interpretation of policy is a matter of law. Applying then the correct lawful interpretation of paragraph 11D to the appeal, it is plain that the tilted balance is also engaged because the policies most important to the decision are out of date. It is accepted that the proposal conflicts principally with policies RLP2 and CS5, with limited conflicts with policies RLP80 and CS8. Taking those policies in turn. Before considering the agreement on the out-of-datedness of RLP2, the requirements of the framework should be laid out. The NPPF requires that policy identify the number of homes needed within an area, called the housing requirement. The NPPF then requires that policies identify a sufficient supply of sites to meet that housing requirement. Policy RLP2 seeks to direct development to meet a housing requirement that is no longer the need of the district. This analysis is clearly set out in Mr. Carville's proof, concluding at paragraph 5.4.1 on page 28. On RLP2, deliberately precise questions were put to Mr. Tivy in cross-examination and clear answers and concessions were given. It was agreed by Mr. Tivy, the following were agreed by Mr. Tivy, that RLP2 is a settlement boundary policy that applies to all settlements and does not distinguish between them, that it directs development to be delivered within those settlement boundaries, that the settlement boundary established through RLP2 was based upon the BDLPR housing requirement of 10,300 over 15 years or 687 DPA. The current adopted housing requirement is now 5,352 over 5 years or 1,070 DPA, nearly 400 more units per year. It was agreed that the settlement boundary in RLP2 is not suitable for directing the delivery of 1,070 DPA. This is because it was based on a significantly lower requirement. On this basis, as it was very clearly put, it was agreed in terms that RLP2 is out of date. Furthermore, RLP2 being unsuitable to direct the development of the adopted housing requirement does not change whether the council has a 5-year supply or not. Therefore, it remains out of date in both circumstances. In contrast to the clarity of the answers from Mr. Tivy, there was a series of extreme examples and confused hypotheticals put by Dr. Bowes to Mr. Carville in cross-examination that took the council's case precisely nowhere, if indeed the questions themselves could be deciphered. RLP2, it is agreed, and was not reneged taken by events, it is inconsistent with the framework and it is out of date. There then followed an unfortunate attempt by Dr. Bowes at re-examination. I say unfortunate because in principle, it is inappropriate to go behind a clear concession of a witness, which is precisely what was done. It was also unfortunate because it was based on what I will generously characterise as a misunderstanding of the basis on which the agreements were given by Mr. Tivy. Finally, it was unfortunate because the basis on which Dr. Bowes put his inappropriate re-examination questions was on a misunderstanding of the law. The agreements reached with Mr. Tivy are set out above. It is on the basis that policy RLP2 has been overtaken by events, something which case law tells us is a lawful basis for finding a policy out of date. The events are that the housing requirement has moved on considerably since the boundaries were drawn in RLP2. RLP2 was to direct a housing requirement that is considerably out of date. No question at all was put to Mr Tivy, and it forms no part of the appellant's case, on the basis that RLP2 is out of date because the BDLPR is a time-expired plan. The questions put in re-examination of Mr Tivy focused solely upon the Daventry case. That judgment, as is plain from paragraphs 40 to 42, addresses the point of how one deals with old policies. The principles from Lord Justice Sales are clear, that the mere fact a policy is time expired does not make it out of date. The decision maker must assess the consistency of a policy with the framework. Daventry is not authority for the proposition that a policy cannot be out of date because it was adopted against a now defunct housing requirement, which seemed to be Dr. Bowes' point, although from the convoluted and theoretical questions put to Mr. Carville, even that is not clear. Dr. Bowes relied in closing on paragraph 42 of Daventry to reach a conclusion that policies adopted against revoked plans is not relevant to whether or not they are out of date, and that's his paragraph 48C. This is an incorrect understanding of the case as put by me and the law. Lord Justice Sales states at paragraph 42, as to one, policies HS22 and HS24 were saved in 2007 as part of a coherent set of local plan policies, judged to be appropriate for the council's area, pending work to develop new and up-to-date policies. There was nothing odd or newfangled in the inclusion of these policies in the local plan, as originally adopted in 1997. It is a regular feature of development plans to seek to encourage residential development in appropriate centres and to preserve the openness of the countryside, and policies HS22 and HS24 were adopted to promote those objectives. Those objectives remained relevant and appropriate when the policies were saved in 2007, and in general terms, one would expect that they remain relevant and appropriate today. At any rate, and this is my emphasis, ma'am, that is something which needs to be considered by the planning inspector when the case is remitted, along with the question of the consistency of those policies with the range of policies in the framework under the exercise required by then paragraph 215. In principle, as is agreed, a policy is not out of date because it relies upon a revoked plan. What the inspector must do here, what you must do, ma'am, and what Lord Justice Sales says as highlighted, is assess RLP2 for consistency with the framework. For all of the reasons given and agreed by Mr Tivy, RLP2 is not consistent with the framework because it seeks to deliver an out-of-date housing requirement. The NPPF requires policy to deliver up-to-date housing need. Policy RLP does not do that and so is out of date. The questions put to Mr Carville in cross-examination were a fantastical ride through conceptual planning theory that we all greatly enjoyed. From it, though, only two things of note emerge. Firstly, Mr Carville agreed that a policy is not out of date because it is in a time-expired plan, a point that is in accordance with the settled case law. And secondly, no agreement was reached that RLP2 is not out of date or that it is up to date. The appellant's case remained untouched. The correct approach to the law and the evidence is as agreed by Mr Tivy and set out above at paragraph 39. RLP2 is out of date because it is inconsistent with the framework, because it delivers an out-of-date requirement, and it does not deliver the adopted need. A consequence of RLP2 no longer being suitable for directing development is that this council continues to grant consents outside settlement boundaries and reduce the weight to RLP2 in their own decision making. And I refer you there to Mr Carville's proof in the Hatfield-Peveril decision, taken in the context of what they say is a 5-year supply. It is also wholly unclear why Mr Tivy reduces the weight to RLP2 to moderate if it is not because it is out of date. Turning to CS5. It was agreed with Mr Tivy that this too was out of date. This is because it is reliant upon RLP2, which is in itself out of date. Without an up-to-date policy telling the decision maker where to apply CS5, it is out of date. Furthermore, CS5 is inconsistent with the framework since it imposes a blanket ban on development in the countryside, other than for uses considered appropriate. Unsurprisingly, ma'am, there is support for the interpretation agreed with Mr Tivy and the application of paragraph 11 in recent appeal decisions in this district. The inspector at Finchingfield at paragraph 73 found RLP2 and CS5 to be out of date because they are based on long outdated levels of housing need. The inspector at Steeple Bumpstead at paragraph 19 finds RLP2 and CS5 to be out of date as they are inconsistent with the framework because they seek to limit development in the countryside only to uses considered appropriate. The inspector at Rain Road at paragraph 54 significantly reduces the weight to RLP2 and CS5, one must assume for out-of-datedness, because the policies are not consistent with the framework in how they restrict development in the countryside and because they are predicated upon long superseded housing requirements. The appellant's position is tolerably clear, and I've repeated it a number of times. RLP2 and CS5 are out of date because they've been overtaken by events rendering them inconsistent with the framework. They cannot deliver the housing need and straightforward requirements of the framework, and this remains the case whether or not the council has a 5-year supply. This approach is right in law, it is supported by inspectors' decisions, and it was quite properly agreed by Mr Tivy. Furthermore, CS8 should be considered out of date as it requires development to enhance the landscape character, something beyond the requirements of the framework. The case of DLA delivery as cited does not overtake the judgment in Telford and Wrekin. Instead, it addresses a different point. Telford was not considered by the court in DLA delivery. DLA delivery addresses the issue of whether or not a blanket policy for the protection of the countryside is in conflict with the framework because the only such policies are reserved for the Greenbelt and at the time valued landscapes. Telford, again not referred to in the judgments of the High Court or the Court of Appeal, finds such policies out of date because it does not allow for a balance to be struck, and that is inconsistent with the framework. Compliance with the development plan. It is agreed that there is conflict with out-of-date policies CS5 and RLP2. The conflict with CS8 is very limited and relates solely to the third substantive paragraph. It was agreed with Mr Tivy that the development has had regard to the character of the landscape and its sensitivity to change through the LVA work and Mr Holliday's evidence. The planning guidelines in the 2006 LCA have been met, see Mr Holliday's evidence. It cannot be known if the site complies with the landscape character areas, as there is no site allocation DPD or SPD. Similarly, there is only a very limited breach of RLP 80 in as much as the landscape feature of the site will be lost because it will be built upon. Fundamentally, with regard to CS8 and RLP 80, this development will integrate well into the landscape and any harm will be at the most localised level to the site. I confess to remain mystified as to how a scheme could fail to preserve the landscape characteristics, as Dr Bowes claims, and not also therefore fail to enhance it. The policy is out of date. There is no conflict with RLP 86 because there is no development in the area identified in the proposals map, and the policy only applies to that area. Both Mr Tivy and Dr Bowes sought to imply protection of the setting of the river corridor into the policy. And ma'am, this is an addition, I'm afraid. One can only apply the policy as it is written, and there is no mention of setting in the policy, as Mr Tivy agreed in cross-examination, brackets, not that this admission prevented Dr Bowes making submissions to the contrary, again, close brackets, that the policy does not protect the setting of the river corridor as defined. Sorry, ma'am.
Could you just, can you read that out?
So one can only apply the policy as it is written, and there is no mention of setting, and Mr Tivy agreed in cross-examination that the policy does not protect the setting of the river corridor as defined in policy. That's the river corridor is defined in policy through the proposals map.
Okay, thanks.
Thank you. Mr Tivy's comparison with conservation areas and the protection of their setting was frankly ridiculous. The setting of conservation areas is specifically protected in national policy. Indeed, in RLP 86 terms, there is an enhancement to the river corridor, as the community park will provide, for the first time, access to the river corridor in this location. It was agreed with Mr Tivy in cross-examination that the development complies with policy CS7. Finally, there is compliance with policy SP3. Mr Tivy agreed that it is only the first 2 paragraphs of the policy that are relevant. From those, there is nothing about the scale, sustainability or existing role of Black Notley that prevents development adjoining its current built limits. This is because the LPA has consistently granted large consents in other villages of the same scale as Black Notley. And it is agreed that Black Notley is a sustainable location, and the existing role of Black Notley as a village will not be changed by this development. The second paragraph relates only to the future planning of growth as part of LP2. The benefits of the scheme are clear. Affordable housing, significant weight in the context of a reliance on all the sites in the supply coming forward, with variables such as sites not coming forward as expected or affordable housing contributions reducing. Delivery of new open space, including community park, and delivering health and well-being benefits and new leisure opportunities, given significant weight. Economic benefits, given significant weight. This was not disputed in oral evidence with Mr Carville, and Mr Tivy's point was that these benefits could be achieved on a less harmful site. It is not clear which sites he means, as no evidence is produced, and the Council's own evidence base in the 2015 Fringe Assessment is that this site is in the 25% most capable of taking development within the Black Notley area. Even if Mr Tivy is correct, his assessment of harm is reduced with compliance with CS7 and with an appropriate sensible reduction in the weight to landscape harm in accordance with Mr Holliday's evidence. And as such, the weight to economic benefit on Mr Tivy's approach would still go up. Market housing is given significant weight, and this is the same whether or not there is a 5-year supply. Ecology, including a net gain in biodiversity, is given moderate weight. The Council has agreed that a 10% BNG is achievable on this site. Delivery of BNG remains a benefit despite being a policy requirement, because without the development, the BNG will not come forward. Conclusions. Ma'am, the appellant submits as follows. The tilted balance is engaged because the Council does not have a 5-year supply. Furthermore, the tilted balance is engaged because the basket of most important policies for determining the application, RLP2, RLP80, CS5 and CS8, are out of date. Within that basket, RLP2 and CS5 are out of date because they are inconsistent with the framework, as they have been overtaken by events. They were to deliver a housing requirement that is long superseded. It is agreed that they cannot deliver the current adopted housing requirement, and as such are inconsistent with the MPPF and out of date. CS5 is also out of date as it imposes a blanket ban on development in the countryside, inconsistent with the MPPF. That these three policies within the basket are out of date renders it as a whole out of date, because they are fundamental policies relating to where development is directed within the district. In the tilted balance, it cannot be said that the limited harms significantly and demonstrably outweigh the many benefits of the appeal, but many benefits, and the appeal should be allowed. In order to conclude that the tilted balance is not engaged, you, ma'am, must be satisfied that the Council can demonstrate a 5-year supply and that the most important policies are not out of date. If that, ma'am, is your conclusion and the tilted balance is not engaged, then the benefits outweigh the harms on a flat balance and the appeal should be allowed, particularly because the 5-year supply is so marginal and the Council acknowledges that it needs a good throughput of sites to maintain its supply. Overall, this is an unusually well-contained piece of land with a strong settlement edge character. It presents good opportunities for mitigation, a better long-term settlement edge, and positive new areas of green space complementing Coker's piece. It will also provide new and attractive cross-valley views. It is one of the sites most capable of taking development within the area. The limited landscape harms should not stand in the way of delivering much needed homes. Ma'am, those are the submissions on behalf of the appellant.
Thank you, Mr. Robson. Okay, so thank you for that. We're nearly done. Just a couple more things. So the site visits, I said I'd discuss that. So there's no reason for me to do it in any other way apart from unaccompanied. Nothing's arisen during the inquiry. So I'll do it unaccompanied. Now, I did explain that I would have done it this afternoon, but because it's a long way from where I live. I couldn't get there and back in one day. So I'm going to have to postpone it slightly because my diary is completely chock-a-block for the next 3 months. I plan to go this weekend. I don't know whether that's a problem that I'll see it at the weekend. I just want to check that nobody's going to object, because I mean, highways isn't a reason for refusal. So I don't think it matters that it's not, peak times or anything. So if you're happy, then that's what I plan to do. Okay.
Ma'am, just on the site visit,
Yeah.
I think my learned friend or Mr. Carville may be about to come in. I
Yes.
think there is an agreed walking route or agreed viewpoints to visit.
Yeah.
Yes.
You're going to send me something.
Yes, there's a map that's been agreed between the council and the appellant and with the landscape consultants of routes to go and things to look at, and also to go and look at Mary Rook Way. Just in terms of the site itself, it is accessed through a private property, and there are horses on the site, as we've discussed. So perhaps you could arrange it and just confirm it with your office exactly when you're going to go, just so we can ensure that the horses are stabled so you can safely access the whole site without impediment.
Okay. Right. Oh, so that's the problem of going at the weekend. Okay, I'd have to think about that and maybe correspond via my case officer. So in terms of, and do I actually need, so I can't get on the site any other way apart from through a private property?
Yeah, there's a small gate that accesses through. There's a gate that accesses via the kind of property curtilage into the rest of the site.
Right. Okay. So in terms of the gate, I will get in touch. I will probably do it on Sunday morning. So I think it's probably best if whoever owns the gate to just leave it, unlocked. If that's
Yes.
if that's secure enough, it won't release the horses onto the road or dogs or anything like that. Would that?
Yes, I think that should be okay. We'll confirm with your office. We'll check with the proprietor, and then we will confirm via email to your office. And we can do that as soon as the session's closed. So, and we'll have that to you this afternoon.
All right, that's great. Okay, thanks for that. And I'll wait for your email about the walking routes.
Yes, I can provide that as soon. That's already agreed. We've got a map for you, and we can send that through together.
Okay, all right, that's great. Okay, is there anything else that anybody wants to mention?
Yes, madam, there was just one point I wanted to mention, which is just on paragraph 48 of my learned friend's closings. He makes the submission that Mr. Tivy conceded policy CS5 was out of date. Madam, you obviously have a note of what was said, and can I just invite you to, as I know you will, just carefully reflect on your notes of that, because that, I have to say, doesn't tally with my note of the evidence. I'm not suggesting my note will be infallible, but I do have a note of that line of questioning and the points that were put about why it was tied to RLP2, and Mr. Tivy said he didn't accept that. He said he thought CS5 went wider. It was then put to him it was inconsistent because of the framework, and he said, I don't accept that point either, and I would stick with moderate weight. As I said, my note may well be infallible. All I would invite you to do, madam, is maybe just reflect on you as the referee overseeing all of the exchange, just to reflect on that, because in fairness, that's not my recollection of what happened. Thank you for letting me make that point.
Okay.
Ma'am, forgive me. Much like Dr. Bowes did very fairly at the start of my closing, I'm now going to do the same thing and fall on my sword, although mine is not because I drafted it before the inquiry, it's because I drafted it late at night. Yeah. He is right, my note is the same. The agreement from Mr. Tivy was CS5 is not out of date. I put it again, so it's been overtaken by events in the same way as RLP2. my record of that answer was in that regard, but it goes wider than that. So he agreed that there was some reliance on RLP2, but it goes wider than just being totally parasitic on RLP2. So I think that's where
I'm grateful for that clarification.
I think I agree with Dr. Bowes. I don't think he agreed it was out of date. He agreed there is some reliance on RLP2, but there's more than that to the policy.
That's right.
I'm sorry. I of course would not intend to mislead.
Oh, cool. I didn't take it that way.
And I am grateful to my learned friend for that.
Thanks very much.
All right. Okay. Thanks. Thanks very much. Okay. So I'd just like to thank everybody for their cooperation, and it's good that we've finished, bang on time, really. So that's great. And I'm particularly impressed with all the proofs that were put in. They were very focused. I don't always get focused proofs, and but these ones were good. So I'd like to thank all the parties, all the participants who submitted proofs on the quality of them. So thanks very much for that. And I hope members of the public, I'm sure they've been able to view it on YouTube, because I did check that as well, and I saw it was quite well viewed. So I thank the public for their participation, as they have done too. Okay, so that just leaves me to close the inquiry now. One last chance for anything else to be brought to my attention before I press leave on the button.
I am sorry, Bob. Just to be clear on that CS5 point, Mr. Tivy did not agree that CS5 is out of date. I'm still making submissions that it is out of date. It's just I don't have agreement from Mr. Tivy. I wouldn't want you to think that I was backing down. Just that I've got overexcited about Mr. Tivy.
All right.
Thank you very much, ma'am. Can I say thank you, and thank you for what's been a very, I think in general, a good-natured inquiry, and what's always nice to say at the end of inquiry, Merry Christmas.
Oh yes, Merry Christmas everybody, and I hope you all have an enjoyable time off, and you manage to stay fit and healthy throughout.
Yeah. Thank you very much.
All right, thank you. Bye-bye.
Thank you, ma'am.
Goodbye.
Thank you, Dr. Bays.
Thanks, Phil.
Right.